The Constitution was only a bankruptcy compact. This began the most dangerous precedent of all the insular cases. This is where Congress took a boundless field of power. When legislating for the states, they are bound by the Constitution. When legislating for their insular possessions, they are not restricted in any way by the Constitution. Read the following quote from the Harvard Law Review. These courts, then, are not constitutional courts in which the judicial power conferred by the Constitution on the general government can be deposited. They are incapable of receiving it. They are legislative courts, created in virtue of the general right of sovereignty which exists in the government, or in virtue of that clause which enables Congress to make all needful rules and regulations respecting the territory belonging to the United States. The jurisdiction with which they are invested is not a part of that judicial power which is conferred in the third article of the Constitution, but is conferred by Congress in the execution of those general powers which that body possesses over the territories of the United States. Harvard Law Review, Our New Possessions? Page 481. Here are some court cases that make it even clearer. The United States may acquire territory by conquest or by treaty, and may govern it through the exercise of the power of Congress conferred by Section 3 of Article 4 of the Constitution. In exercising this power, Congress is not subject to the same constitutional limitations as when it is legislating for the United States. And in general, the guarantees of the Constitution, save as they are limitations upon the exercise of executive and legislative power when exerted for or over our insular possessions, extend to them only as Congress, in the exercise of its legislative power over territory belonging to the United States, has made those guarantees applicable. Hooven and Allison and Company v. Evatt, 324 U.S. 652, 1945. The idea prevails with some indeed. It found expression in arguments at the bar that we have in this country substantially or practically two national governments, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument, by exercising such powers as other nations of the earth are accustomed to exercise. I take leave to say that if the principles thus announced should ever receive the sanction of a majority of this court, a radical and mischievous change in our system of government will be the result. We will, in that event, pass from the era of constitutional liberty guarded and protected by a written constitution into an era of legislative absolutism. It will be an evil day for American liberty if the theory of a government outside of the supreme law of the land finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violation of the principles of the Constitution. Downs v. Bidwell, 182 U.S. 244, 1901.